To continue on, so also the area of social media is a big area for fluctuating law and privacy as well. So we have two cases that are the opposite of each other in many ways, making social media and privacy very confusing. So we've got a New Jersey case that ruled that just because you put something on Facebook and you post it to your followers, it doesn't mean that it can be shared with people who are not your friends. And if it is, it's a violation of privacy. And that's kind of crazy, right? Because you can find what people put on their Facebook feeds, even if you're not a friend, and you can cut and paste it and put it elsewhere, but it actually is against the law. In New Jersey, it's a violation of privacy. Meanwhile, in California, a person who posts a complaint in a newspaper is allowed to do that if they are publishing complaints that were made on social media. So you can take a Facebook feed and you can report on it in a newspaper, and it's not a violation of privacy. So privacy is still an area of media law that has to be fleshed out. All right, let's move now to the area of free press / fair trial. Free press / fair trial. So we have two amendments that guarantee that there will be a fair trial no matter what the accusations are. And that's a cornerstone of our law, that no matter how guilty you look, that you get to have a fair trial. So we have the 6th Amendment, we have the 14th Amendment. The 6th Amendment guarantees an impartial jury for individuals in the media. The 14th Amendment guarantees the same thing, an impartial jury, but for criminal defendants. So you have a right to be judged by your peers, and those peers cannot have biases. One of the cases that help clarify how this can be played out in a court system is the case of Sam Shepard in 1954. Sam Shepard. So Sam Shepard was a doctor, a medical doctor, and he was accused of murdering his wife. And what happened was his wife was murdered, and when the police came to investigate, Sam Shepard told them that there was an invasion by nappy-headed intruders. Nappy-headed intruders. He was being racist, right? He was implying it was black people who invaded his house and murdered his wife. Well, then the press got a hold of information that Dr. Sam Shepard was having an affair. And that set off a media frenzy. It's not like today. Affairs are treated more commonly, but in the 1950s, to be in the press. And so everybody who is accessing the stories in the media, or almost everybody, had a guilty impression for Dr. Sam Shepard. So even though he was convicted, the Supreme Court ruled that he did not receive a fair trial, and therefore he was found innocent because he didn't receive a fair trial. And actually this court case came up with some remedies, as they call it, remedies for future court cases in case there are potential biases. To fix the biases, one is a gag order that courts can use. And that's where a judge says, oh, I'm going to put a sock in your mouth, effectively, and you cannot speak about this if you're the prosecution or the defense. You're prohibited from speaking about it. So that's one way to stop the public from being influenced unfairly. Secondly is you can sequester the jury. You can say to the jury, okay, you have to stay in a hotel, give me all your cell phones, can't watch any television until you come with a verdict, sequester the jury. Thirdly, you can postpone the trial. You can say, okay, there's too much emotion right now, we're going to do it at a later date. And fourthly, you can change the venue for the trial. You can say, you know what, too many hurt feelings, too many emotions in this area, we're going to move the trial to another area. That's what happened to That's what happened to Eric Frayne. Eric Frayne, you know him, right? He was an ESU student at one point, and then he, as a court of law found, he committed murder by assassinating a Pennsylvania state trooper outside of the Swiftwater barracks. And then he went into the woods, Eric Frayne did, and he hid for, I think it was like 60 days. It was terrifying. I was teaching a class at that time. I had students living in the Cresco area where he was. He was eventually found in an abandoned airplane hangar. But the anger towards this guy was so great that they moved his trial to Phoenix, Pennsylvania, down by Philadelphia. And you can thank the Sam Shepard case for that remedy. Another case that comes to play here is the Oklahoma City bombing case in 1995. Timothy McVeigh was the perpetrator of that, and that's probably the most important free press fair trial case in the last 30 years, where they actually moved the trial from Oklahoma City because Timothy McVeigh bombed a federal building and brought it down and killed many federal employees. He was anti-government. They moved that case to Colorado. and that's to demonstrate the length to which the court system will go to ensure fairness. Also, we can talk about cameras in the courtroom. That's a controversial area, and whether they do influence the public. If you have a camera in the courtroom, right, you can have a person who's very visual, who's very good looking, a person who knows how to work to the camera, can play on sympathies, can influence public opinion can influence the jury. So it's controversial. And many states do allow cameras in the courtrooms. We've seen cameras in the courtroom with recent cases, very recently racist cases having to do with the court system and police officers. Not the police are racist, I'm not trying to say that, but court cases. Derek Chauvin, for example, we've seen cameras in those courtrooms. However, at the Supreme Court level, cameras are not allowed because of the concern that cameras can influence the outcome. Now, to what extent is there control over the press? To what extent does the law allow for control over the press? Well, Congress passes laws all the time to control the media, which is synonymous with the press. Congress passes, there's a law right now that you cannot use the word fuck because it's considered to be obscene. And if you use that on radio more than once, because there's also a provision, which is a law, that's called the fleeting expletive rule, meaning you can make a mistake one time and say fuck, but if you say it twice, now you're not being careful, you can be fined, get this, over $300,000. We live with that every day at WESS. So Congress can pass laws, but also laws come out of the court system. So let's look at the court case Cohen versus Cowles. Cohen versus Cowles. So this is a case about a Republican in Minnesota. His name was Wheelock Whitney. Wheelock Whitney, in a different name by what we hear today, Wheelock, Wheelock, Wheelock Whitney. He was running for the governor of Minnesota, and he found out that his opponent had been arrested for theft. So what he did was he hired a PR person, that person's name was Cohen, and he hired that person to reveal the theft to reporters, but the Republican Wheelock Whitney didn't want to be fingered for it, right? So he paid somebody to do it anonymously. So unfortunately, 2 newspapers ran the story, and they identified Cohen anyhow as the source of the story. So Cohen sued the the PR person sued, and he won. The courts ruled that you have to live up to contracts in the media. You can't reverse contracts, even though the story was interesting to the public. But then we have an alternate ruling, which is in the court case Food Lion versus ABC. Food Lion is a big grocery store, and it's located mostly in the South. And there was word in a Florida community that the Food Lion there was practicing unsafe conditions with its meat. So ABC, under the program Nightline, you know that show late at night, it's a news magazine, Nightline, they went down to Florida, they had 2 reporters, and they got hired by Food Lion. They applied for jobs, they got hired, and once they got hired, they went into Food Lion with cameras hidden in their buttons of their white frocks, if you want to call them that, and they captured meat that had been hung up longer than it should have been. They captured employees handling meat with their hands and not using gloves, and they busted Food Lion for unsanitary conditions. And Food Lion sued them. They sued ABC because ABC had 2 reporters that lied to them. So this court case went through the system, and the jury came back, and they found Food Lion guilty. But here's the thing. They made the penalty $1. $1 is a penalty. So in effect, the jury was saying, we are going to say that the law says you cannot lie when you apply for a job, that you're not really a reporter, pretending that you're not. You cannot do that. But at the same time, it was so valuable that we had this information. It was in the public interest to know that Food Lion is unhealthy, and the Food Lion is serving food, is preparing its meat in an unsanitary way, that we're only going to fine $1. All right, let's move now to another area of the law called prior restraint. Prior restraint, also sometimes known as censorship, though they are not quite the same. Censorship is when the government takes content away and says you can't publish it. Prior restraint is where editors and reporters say, we are not going to publish this content. We're going to choose not to do it because we know we'll get into trouble. So where does this come about? So it's one of the areas that we find its origins is in the court case Neer versus Minnesota. Neer versus Minnesota. So what this court case is about is J. Neer. J. Neer was a publisher of a newspaper called the Saturday Press. It was a racist and particularly anti-Semitic newspaper. It was often making disparaging remarks about Jews. So there was a lawsuit on the part of a Jewish organization against J. Neer and the Saturday Press, and the courts ruled in Neer versus Minnesota that the government cannot suppress a publication. You cannot stop J. Neer from publishing his offensive content unless it is revealing military information during a war or unless it is obscene information. So right away we have those two hallmarks of what's going to be information that's prohibited in our country, which is not part of our free expression. That's military information, obscene information. We do not have an absolute First Amendment in this country, in other words. Another court case that comes to bear is the Pentagon Papers. The Pentagon Papers. So the United States was in this terrible conflict called the Vietnam conflict. Some people call it a war. It was not officially a war. And the American public wanted to know what was going on. What were we doing over there? What was our strategy? What was our end goal? What was our mission? What were our objectives? And the U.S. military decided to conduct a study of itself. And when the study was done, it did not want to release the study because it did not paint a good picture of U.S. strategy. But there was a leak of that information from somebody in the military to the New York Times. The New York Times decided to print that paper, and then the government, on behalf of the military, issued an injunction stopping the New York Times from continuing with that information. And then the Washington Post decided to pick up that information because the New York Times gave it to them, and they started publishing it. And ultimately we get New York Times versus the U.S. government in the case of the Pentagon Papers. And the courts ruled that the publishing papers did not present a grave, important word, serious, grave and immediate danger to the public. So the Washington Post could publish that information. So we have a lot of court cases establishing free expression, but it's not absolute. Now, what about students? What about if you're at a school newspaper or at a radio station or a TV station, or if you're running Twitch for a video gaming operation at your university? What are your freedoms? Well, Hazelwood versus Kohlmeyer, that court case is very instructive. So here we have a student newspaper at a high school where they wanted to do a story on teenage pregnancy, females who are single and who are carrying a baby in high school. And the principal got a hold of this news and they said, no way. So the story came out, and the principal blacked out all the names of the females. The newspaper had tried to protect the names anyhow, but the principal blacked out parts where he thought would reveal the identity of the students anyhow. And this went to the newspaper sued the principal. It went to the courts, and the courts ruled that yes, the principal has the right to sue, has the right to censor. So therefore, student media can be censored, but the courts ruled that the newspaper or the radio station has to be part of a college curriculum. So that is when a university can suppress speech, in other words. Now let's talk about so-called shield laws. Shield laws are very interesting. Shield laws are laws that are done at the state level usually, like Pennsylvania has its own shield laws, New Jersey has its own shield laws, and it's designed to protect a reporter from having to reveal their sources, which is very important to reporting. Because if you have corruption occurring in government or in any company, in order to get somebody to talk, a lot of times they say, well, I want to be off the record. I want to be anonymous because I might lose my job or my family's safety might be threatened. And so you have to have shield laws. And Pennsylvania's shield laws protect Pennsylvania reporters from having to reveal their sources. Although there have been cases of reporters being put in jail for brief periods of time. Judith Miller from the New York Times put in jail for refusing to reveal who had leaked information to her about a CIA agent. She served 85 days in jail. Nonetheless, mostly journalists have protection. Now we're going to go to obscenity. This is the way that we started out class today. And we have the court case Neer versus Minnesota, which did establish that obscene material is not protected by the First Amendment. We already talked that's an anti-Semitic case. But there are two more cases that have supposedly clarified obscenity law in this country. One is Roth versus the U.S., So Roth ran a business selling sexually explicit books, and he used to mail those to the United States Post Office. And there was a court case that went to trial based on Roth being obscene. It was the United States brought this case, And they found Roth guilty and developed a 3-part test to determine if something is obscene. One is that the standard for obscenity has to be set by the individual community using an average person. So what is obscene in New York City may not be obscene in Ames, Iowa, because it's based on the individual person. Secondly, the work must be taken as a whole. You cannot just examine one utterance of a word without looking at it. Penis, for example. Was penis used in the context of a medical public service announcement advising people to use condoms? If it is, that's taking the work as a whole. It's not obscene. And finally, the work must appeal to, here's a new word for you, prurient interests, which are primal interests. Those are, you can basically say, a person's horny urges if you want to. And that's supposedly how you can judge whether a work is obscene. Another law came along supposedly to clarify obscenity further. It's Miller versus California. And Miller versus California added 2 points. One is child pornography is illegal at all times. And secondly, if material has serious literary or artistic or political or scientific value, then it's not obscene either. So that's why a book like Lady Chatterley's Lover, do you know about that? Lady Chatterley's Lover, it was a book written in Elizabethan England. It was about adultery. That book is supposedly a serious literary work, so it's not going to be considered to be obscene. Still, this area of law is murky. I've been saying it's murky the whole way through. Pennsylvania has a law on revenge porn, right? If you are in a relationship with somebody, you cannot, just because you're mad at them or they did something to you which was unethical, you can't put your sex online or text somebody with it. And we're still finding this playing out. There was a famous court case in 1999. Larry Peterman, in 1999, was the owner of a video store in Utah. And he was charged with renting obscene films, signing them out through VHS or DVD. I'm not sure which at the time.